Today we are going to discuss the area of misrepresentation in greater detail. Common law contract law, like civil law contract law, is centered around the concept of a meeting of the minds. No contract can exist without this, and if there has been no meeting of the minds, then a contract will not be considered to exist between the parties. Normally, a meeting of the minds occurs when there is an offer and acceptance of that offer. However, even if there is an offer and acceptance, the presence of vitiating factors will prevent a true meeting of the minds from taking place. Misrepresentation is one such vitiating factor. Now let's take a closer look at the area of misrepresentation. Part of the difficulty with understanding the notion of misrepresentation centers around two issues, namely one, the type of statement that can be considered as coming within the definition of a misrepresentation, and two, the relationship between misrepresentation and tort law. So what statements can be considered as coming within the heading of a misrepresentation? Clearly, not all written or oral agreements made by the parties leading up to the formation of a contract can be considered to make up part of the final agreement. In this regard, the common law identifies three main types of communication in the area of contract negotiation and formation. The first is sales puff. Statements that come within the definition of sales puff are general positive statements of opinion that one can expect to hear from a seller. Such general statements of opinion are not normally considered to create any contractual liability toward the other party. The second is representations. Representation is a pre-contractual statement of fact that, although inducing the other party to enter the agreement, is not sufficiently close or relevant to the conclusion of the bargain to actually make up a term of the contract. In other words, it is not an essential element in the deal. Breach of a representation does not give a party a right to bring an action for breach of contract. However, it may be possible to bring an action for misrepresentation. And terms, number 3. The terms of a contract define the actual scope of the agreement entered into by the parties. In the case of oral contracts, only those communications central to the actual agreement will be considered to make up a term of the contract. If a term of the contract is not respected, the other party may bring an action for breach of contract. The terms of the contract may be expressly agreed by the parties or implied by the courts. So how do we distinguish between representations and terms? Thus, as we have seen, the law of misrepresentation only concerns representations. It is sometimes difficult to distinguish between representations and terms. Generally, a communication will only be a term of the contract when it is an essential element of the agreement, while a representation, although significant to the negotiations, is not considered essential to the bargain. In the case of written contracts, under the parole evidence rule, there is a rebuttable presumption that the terms of the contract between the parties are limited to the scope of the actual written agreement. Thus, any document or statement not expressly included in the written agreement will probably be considered a representation and not a term. More generally, the common law is inclined to interpret the notion of representation broadly, classifying many communications that might easily be thought of as contract terms as representations. As we have seen, if a term of the contract is not respected, it is possible to bring an action for breach of contract. However, if a representation turns out to be untrue, liability will exist not under the heading of breach of contract, but under the law of misrepresentation. Now, finally, we have to consider the relationship between misrepresentation and tort law. There are three types of misrepresentation. If a statement is made deliberately with the intent to defraud, it is said to be a case of fraudulent misrepresentation. If it is not made with the intention to defraud the other party, it is said to be innocent misrepresentation. And finally, if a misrepresentation is made carelessly without sufficient care being taken as to its veracity, it is said to be negligent misrepresentation. Depending on the classification of the misrepresentation, different areas of law may be involved. In the case of fraudulent misrepresentation, it can give rise to an action in contract law for damages and rescission. Rescission is the equitable remedy of restoring the parties to the position they were in prior to the contract, or a remedy in tort law under the tort of deceit. In the case of innocent misrepresentation, a party can sue the other party in contract law for rescission of the contract, and in some common law jurisdictions may be able to claim very limited direct damages resulting from their reliance on the misrepresentation. And finally, there is negligent misrepresentation. In the case of negligent misrepresentation, an action for damages should be taken under the tort law of negligence. We hope you enjoyed this introduction to the notion of misrepresentation in common law, contract law.